Great. So as always, good morning, good afternoon, good night, wherever you are, to everyone. Welcome everyone to this week's Law Science event. Welcome also to those who will rewatch this session later. I'm Daniel Hefke. I'm a JSD candidate at Cornell Law School and the moderator for the session. Before turning to today's speaker, Adam Sitze, I will briefly introduce the Law Science Project. We are an academic initiative coordinated by a group of JSD students who share the same belief in legal methodologies, which are often understood as a discipline distinct from sciences, traditionally consisting of doctrinal analysis, normative questions, and through the series of interdisciplinary talks, we aim to show that legal research can really be improved and benefit from an interaction with science and from learning from scientific methodologies that provide more systematic ways to approach questions. If you want to learn more about law science, please visit our website or join our email list. One of the coordinators will drop the links in the chat, and that's actually a good point to introduce our coordinators besides me. So we have Simon Sun. He's an SJD at Indiana University Maurer School of Law and the co-founder of this initiative. And we have Marilyn Hush. She's a JSD candidate from UVA. We also have representatives at diverse other law schools in the US, such as Berkeley, UPenn, University of Illinois, Georgetown, University of Washington, Columbia, Fordham. If you're interested in getting involved, we are always looking for new law science representatives. We also host a blog on legal methodology called the Legal Method Lab, for which we are currently searching for the editors. So if you're interested in becoming either a representative or an editor, you will find a link in the chat for that as well. But let's turn to our speaker for today, Adam Sitze. He's a professor in law, jurisprudence, and social thought at Amherst College. His scholarship is broadly focused on the relationship between truth and law. He has authored a book on South Africa's Truth and Reconciliation Commission, and he has authored many articles in the field of the law and the humanities, such as law and literature, the philosophy of law and critical theory. Lately, he has written and commented insightfully on university politics and academic freedom. It is a great pleasure to welcome him to this semester, this semester's Law Science series. The session today will concern a rereading of Roscoe Pound's seminal 1908 essay, Mechanical Jurisprudence, and its teachings on the relations between science, law, and life. We will have time for Q&A at the end, so if you're interested, please prepare questions. The event will be recorded and uploaded to YouTube, so you can either raise your hand if you have questions or just write them down in the chat, and then I will read them out for you. But now, without any more further ado, thank you so much for joining us, and the floor is yours, Professor.
All right. Thank you, Daniel. Thank you, Simon. Thank you, Marilyn, for this invitation. I'm really excited to talk today, and here we go. So today I'm going to talk about Roscoe Pound's 1908 essay, Mechanical Jurisprudence. Although he's somewhat neglected by contemporary scholarship, Pound is one of the foremost American legal philosophers of the 20th century. He was dean of the University of Nebraska's College of Law from 1903 to 1911, and dean of Harvard Law School from 1916 to 1936. He's best known as the father of sociological jurisprudence, which, as I'm sure you know, blended legal concepts with pragmatism and social science into a new synthesis that replaced the sterile conception of law as a closed system of timeless doctrine. He also made important contributions to comparative law, Roman law, and criminal justice reform. His 1908 Mechanical Jurisprudence essay is, by any measure, a classic of American legal theory. Often interpreted in terms of the opposition between conservative 19th century formalism and early 20th century progressive sociological jurisprudence, his essay, in fact, contains a surprising set of teachings about the relations between science, law, and life. As I've said, I'm going to talk, in this talk, I'm going to translate and gloss those teachings into language that I think will make those teachings available to jurisprudence today. I'm going to call these teachings theses, and I have three that I'd like to discuss today. My first is quite general. It governs Pound's text without also being fully expressed in his text. It's that the desire for science is not itself scientific. Logically speaking, the desire for science precedes science itself. But to the exact extent this desire is pre-scientific, it also exceeds the limit of the scientific, and what exceeds the limits of the scientific is therefore also, in some way, also unscientific or non-scientific. This rather innocuous thesis has a serious consequence. To the extent that or non-scientific desires motivate science, guide and direct it, chart out its paths and goals in advance, then science can't be fully scientific either. For science that serves non-scientific ends or expresses non-scientific desires is science that hasn't completely rid itself of its antithesis. This problem, I think, is as old as Aristotle, who wrote about it in book A1 of the Metaphysics. It was revived by the great critics of modernity's faith and reason, Nietzsche and Freud, both of whom radicalized the split between the subject of desire, whose wish is his command, and the subject of reason, who is governed by the epistemic imperatives of consistency, universality, empiricism, skepticism, certitude, what have you. The great claim of these critics, broadly stated, is that if the desire for reason does not itself partake in reason, if then reason originates in unreason, then in principle it should always be possible to show that reason's origins are non-identical with its formal self-presentation, that there exist traces within reason of the silent structures of an unreasonable unconscious. This critique doesn't necessarily entail the relativistic claim that there is no difference between reason and unreason, although admittedly that claim is always a danger. It instead, I think, requires of us a certain sort of intellectual humility, for it teaches us that reason can be certain that it's not contaminated by unreason. Now, there's no evidence that Pound read Nietzsche or Freud carefully or indeed at all. Nevertheless, Nietzsche and Freud are merely examples of a longer tradition that's more extensive than them, and traces of that same tradition are at work in Pound's essay. I'm thinking in particular of the argumentation that occurs at the outset of his essay. Here's a gloss. The desire for scientific law, the wish that law should become a science, is not mainly or simply or primarily a desire for science itself. As Pound will say, quote, law is not scientific for the sake of science, end quote. It's scientific in order to prevent whim, caprice, corruption, and arbitrariness. It's scientific in order to make law more certain, more predictable, more uniform, more equal, more exact, and more coherent. But all of these ends, or as I think Pound would say, all of these adjectives, are the traditional attributes of justice itself. They're the qualities we desire when we traditionally desire justice. Here as elsewhere, therefore, science is the expression of a desire that's not in and of itself scientific. As Max Weber would similarly argue in his 1917 lecture, Science as a Vocation, science itself can't scientifically posit the ends at which it aims, and it can't evaluate the value of those ends either. The desire that guides our inquiry into the relation between science and law, it would then seem to follow, has little to do with either science or law. It has primarily to do with a manifestly philosophic question. In order to integrate science and law, indeed as the prior condition for integrating science and law, we first need to know why it is that we want to integrate science and law at all. At the root of the desire for science and law is thus a question that can be investigated independently of both science and law, and for Pound, that is the question of justice. In the case of jurisprudence, the non-identity of desire and reason has serious consequences. Scientific law, Pound will argue, has two dangers. The first is that the more scientific law gets, the more opaque it will become to the public, whose voluntary obedience law requires as a condition for its concrete efficacy. In particular, Pound will assert, the administration of justice requires what he calls the public's reverence for the sacred traditions of legal institutions. This reference is what thinkers like Weber, also Carl Schmitt, who was in the audience on the day that Weber delivered his lecture in November of 1917, would call the legitimacy of legality itself. The idea is that legal institutions derive their authority thus to the voluntary obedience of actually concrete populations from sources that are not themselves legal in character, and that legal institutions can themselves undermine occasionally through an excess emphasis on legality alone. At the close of mechanical jurisprudence, Pound will pose a question that remains important to us today. What is a good lawyer? He'll answer with a quote from Ulpian's Digest. Because law is the art of the good and the equitable, we jurists deserve to be called priests. Elsewhere, Pound will similarly suggest that judges should be, quote, the living oracles of the law. In both cases, his language is revealing. When an oracle speaks, we understand the verdict that's being announced, but we don't understand the methods by which that verdict is attained. We say, I don't understand how you've reached your verdict or why you've reached your verdict. I only understand that your verdict is your verdict, and that your verdict carries a certain weight or gravity I recognize as authority. For the judge to be a living oracle, therefore, the public has to agree to obey what it doesn't fully understand. Mechanical jurisprudence, I take Pound to argue, presses this tension beyond its limit. The more that the administration of justice becomes scientific, Pound argues, the less the public will understand it, for the more advanced and specialized science becomes, the more its methods will have the appearance of artificiality and arbitrariness, and the more difficult it will become for the public to maintain an attitude of, quote, reverence. In this way, mechanical jurisprudence makes it difficult for legal institutions to maintain the non-legal legitimacy on which they depend as a condition for their continuity over time. The danger, it would seem, is that the more that law becomes science, the more jurisprudence is tempted to misunderstand its reliance upon science's ostensible antithesis, the religious, for its continued efficacy. If then the risk of a fully scientific law is that it will no longer be revered by the public as if it were a religion, the danger of a fully mechanical judge is that he or she will no longer be obeyed by the public as if an oracle. A judge of this sort is thus likely to upset the unstable equilibrium between faith and knowledge, between reason and revelation, on which legal institutions concretely depend. On to the second danger. This has to do with the legal profession itself. To the exact extent mechanical jurisprudence results in a complete deductive system, Pound argues, the result will not be perfection, but petrification. Under conditions where the scientific codification of law attains an exhaustively complete form, there no longer would be any reason for younger generations of jurists to pursue the scientific study of law. The work of prior generations, in this case, will have left nothing more to be desired. To us, the living, it would fall simply to apply and enforce the categories they have devised. The study of law would then be synonymous with the need to submit to what Pound calls the, quote, domination of the ghosts of departed masters, end quote. Paradoxically, therefore, the more that jurisprudence aspires to the status of a deductive science, the more, in other words, that it's mechanized, the more it decays, the more it dies, the more it degenerates, the more it bequeaths to us, the living, a dichotomy between inanimate law and animate populations. According to Pound, the root of these volatile reversals, the source of these two dangers, is what he calls an unscientific concept of science. That concept, Pound will say, derives from the 19th century idea that science amounts to, quote, a rigid scheme of deductions from a priori conceptions, end quote. According to this idea, a mature science, a science that's fully come into its own as a science, is a science that will have attained the form of a complete and exhaustive system of rules. It's a science that not only discovers, but also codifies the laws of the universe. In Pound's view, The problem with this concept of science, and the reason it is unscientific, is that its vocabulary and indeed its self-image is, quote, borrowed from law, end quote. Stated differently, the idea that science is a complete system of structured deductions from first principles is derived from an extra and non-scientific form of knowledge, the art of jurisprudence. As Pound's later reference to Savigny will indicate, he is here thinking in particular about Roman law, which involves subdivisions such as the law of persons, property, obligations, actions, and so forth, and as such is famously taxonomic and deductive in character. According to Pound, sciences that desire a juridified image of science can't, won't, and don't succeed in their aim. Instead of attaining an actually effective understanding of living organisms themselves, Pound will say, their deductions do nothing more than reconfirm, corroborate, and vindicate the validity of preconceived categories. They impose dead categories on living beings. This is why Pound will say, European science has been moving away from this unscientific concept of science since the scientific revolution, Darwinism, that swept the late 19th century. With this premise in place, Pound is now able to make his most forceful argument against mechanical jurisprudence. Jurisprudence that desires an unscientific idea of science. And that idea, again, is that true science is a science that assumes the form of a specific kind of jurisprudence. This sort of science, this sort of jurisprudence, strangely only ever encounters itself, but in a distorted and unrecognizable form. Because the science jurisprudence aspires to become, itself aspires to become a jurisprudence, mechanical jurisprudence never ends up encountering science at all. Like Narcissus weeping into his pool, mechanical jurisprudence is jurisprudence that not only unwittingly falls in love with its own image, but also destroys itself in the process. Mechanical jurisprudence is thus jurisprudence in the grips of a vicious circle. Far from marking the avant-garde, it therefore, in fact, is, quote, the last in the march of the sciences away from the method of deduction from predetermined conceptions, end quote. It is the last of the sciences, that is to say, to liberate itself from a conception of science that's in turn modeled on law. This twist leads me to my second thesis, and that is the following. Law's true antithesis, the element it most needs to integrate within itself in order to become what it already is not science, but something Pound calls life. Listen carefully, after all, to the way Pound uses the word mechanical in his essay. When he criticizes jurisprudence that's become mechanical, he doesn't, of course, mean that it's literally become a device comprised of steel, engines, belts, and fuel. He means that it's begun to run automatically on its own, unthinkingly, repetitively, involuntarily churning out results that had nothing to do with the actual lives of the populations that revere it and which it governs. The fact that, quote, our case law at its maturity has acquired the sterility of a fully developed system, quote, end quote, he will argue, may be shown by abundant examples of its failure to respond to vital needs of present-day life. And of course, you can hear vital and you can hear life. It's the most pointed edge of his critique. Mechanical jurisprudence is thus not only lifeless in the sense that it is, in its own internal logic, automatic and unthinking. It's also lifeless in the sense that it relates to the everyday life of actual populations in a manner that's itself deadened, unresponsive, and sterile. Here as before, you can see the problem with the lifelessness of mechanical jurisprudence. It ends up throwing into question the institution of law itself. Legal institutions that have no relationship to life, but that nevertheless propose to continue regulating life anyway, are destined to undermine their own authority. In August of 1906, Pound gained fame in the United States for a speech called "The Causes of Popular Dissatisfaction with the Administration of Justice." In that speech, he declared that, quote, "Law is often in very truth a government of the living by the dead," end quote. In the 1908 essay we're talking about now, Pound builds on that thesis. Mechanical jurisprudence is the genre of jurisprudence required by the government of the living by the dead. Anyway, something called life, therefore, will be the standpoint from which Pound critiques the idea that law should become a science. But what exactly does Pound mean by life? The question is far from merely historical, for Pound's claims about life contribute premises to three legal theories that are important today and that remain important today. The first is legal realism, and the scholar Stephen Presser has described this well in a preface to a collection of Pound's writings. This is a long quote from Presser. Legal realism, as practiced in the 1930s, maintained that a sensible and realistic jurisprudence ought to result in altering law and legal institutions to meet the needs of the time, and ought not to pay excessive deference to older concepts such as freedom of contract and restraints on the interference of state and federal governments with private agreements. If Pound's work was an inspiration for legal realism, then Pound is due some of the credit for laying the foundations of legal realism's greatest triumph, FDR's New Deal, Franklin Delano Roosevelt's New Deal. During the New Deal, lawyers trained in legal realism expanded the role of the federal government through plastic interpretations of the US Constitution and the creation of a myriad of new administrative agencies, end quote. In particular, Pound is the source of an idea that is quite dear to legal realism, namely that legal order is, quote, "a process of social engineering," and that jurisprudence is a science of social engineering. This idea, which is central to the jurisprudence of the welfare state, is generally associated with progressive New Deal politics. Today, however, a version of it is being revived under the very different rubric of common good constitutionalism, which holds that muscular uses of state and federal government are appropriate as means to the end of ordering society around the objective moral principles of natural law. Under such a regime, as Adrian Vermeule has argued, the idea that, quote, "each individual may define one's own concept of existence, of meaning, of the universe, and of the mystery of human life," end quote, would not only be rejected, but be stamped as abominable beyond the realm of the acceptable forever after. All of that is Vermeule. Instead, according to common good constitutionalism, government should define the basic contours of the good life up to and including our idea, most notably, about the beginnings of life, and enforce that meaning with what Vermeule calls, quote, "a powerful presidency ruling over a powerful bureaucracy," end quote. I'm going to come back to this later. The third legal theory, in the meantime, I have in mind very briefly, is living constitutionalism, which holds that constitutional law can and should evolve, emphasis on evolve, in response to changing circumstances and values. As Georgetown professor Lawrence Solom has observed, Pound's use of the phrase living constitution in this essay, it's right in the essay, is one of the earliest recorded appearances of that phrase in the American legal tradition. Okay, very different legal theories. Despite their differences, they share a common feature. They are, at the deepest level, responses to a question that Pound poses in his essay. How should we jurists respond to a situation in which jurisprudence itself is not only mechanically undoing the legitimacy of legality itself, but also at the same time knocking the relation of law and life out of joint? What remedies can jurisprudence offer to counter this state of affairs? In particular, to what conception of life can jurisprudence turn to rectify the lifelessness of mechanical jurisprudence? Here, a biographical note is in order. As some of you may know, in 1898, Pound received the first PhD in botany ever awarded by the University of Nebraska. He made substantial scholarly contributions in this field. In 1898, for example, he authored the groundbreaking book Phytogeography of Nebraska. That's spelled P-Y-H-T-O, Geography of Nebraska, which was the first book-length study of its kind in the English language. It was a comprehensive statement of the developing field of ecology, and it became a landmark in American botany. As I earlier implied, Pound's training at Nebraska was heavily influenced by Darwin. On the basis of his studies of evolution, he became polemically opposed to the postulates of Linnaean taxonomy, according to which the ultimate act of science is the proper classification of organisms into kingdoms, phyla, classes, orders, genera, and species. He instead adopted a conception of life based on the ways in which species adapt and change over time through the processes of natural selection and genetic mutation. In this conception, importantly, life does not have its telos outside of itself, in this or that concept of the good, just, or beautiful. A telos is a goal or a purpose. Life's telos is instead immanent to itself. For Darwin, as to some extent for Hobbes, the goal of life is simply more life. Tomorrow and tomorrow and tomorrow, life is nothing more than a competitive struggle for the preservation, prolongation, and enhancement of life. This concept of life explains not only the scientific basis of Pound's critique of the lifelessness of mechanical jurisprudence, I think it also illuminates the limits implicit in the way he uses life as a basis for the critique of mechanical jurisprudence. So in other words, that Darwinian concept of life, I think, has real constraints built into it, and I'm going to explore that in the following. But first, let's kind of gloss Pound. Science is unscientific, we may take Pound to say, when it limits itself to the act of properly classifying and naming an organism. That, as he will say at the end of the 1908 essay, that's magical thinking. It's a belief in the mystic power of words to control reality. The idea that I taxonomize something and therefore understand it is magical thinking. Real science, by contrast, is the act of understanding the way in which life changes over time in response to its environment. By extension, real science involves a control of reality that's not mystic but real, and that in particular assumes that the mutability of organic life renders life available for social engineering. The true integration of science into law would not then result in a perfect system of deductive categories, as we've seen. It would result in a twofold relationship between law and life. On the one hand, a properly scientific jurisprudence would need to learn to adjust legal rules and norms to the changing conditions of human life. This is basically living constitutionalism. On the other hand, and conversely, a properly scientific jurisprudence, not a mechanical jurisprudence, but a properly scientific one, would need to embrace the possibility of adjusting human life itself, or rather of engineering it by means of changes to legal rules and norms. With this, we encounter the most basic presupposition and the most active epistemic kernel of Pound's arguments about science and law, in my view. Earlier, I stated the second thesis I derive from Pound's text. The idea that law's true antithesis is not science but life. Here we have the corollary to that thesis. In Pound, but not only in Pound, justice is a desire for the dual and reciprocal adjustment, for the continual modification of law by life and life by law. Okay, supposing that's true, what then? Then I think we'd have to contend with at least one further corollary, namely that justice so construed seems to require seems to require not just a legislative reform that allows judicial decision-making to start afresh, as Pound says at the close of his essay. It also involves something else, a legal theory I think we may fairly call decisionism. Here's what I mean. The more that jurists abandon formal rules because of those rules' generality, artificiality, and abstraction, the more that jurists lose the epistemic capacity to group like cases together with other like cases, which is one of the primary functions of rules in jurisprudence. The more jurists instead will be obliged to adapt law to the unique facts of each concrete case. But to the extent that the facts of each concrete case really are sui generis and not generalizable beyond that case, the more jurists also will be obliged to abandon the traditional idea that justice ought to be characterized by norms of predictability, consistency, uniformity, equality, and coherence. For without general, abstract, and formal rules, and without the ability to adjudicate like cases in like ways, such norms by definition become unattainable and ineffective. The counterpart of a concept of life whose telos, whose purpose, whose goal is entirely immanent to itself, is thus a judge whose decisions don't transcend the cases that come before him or her. But because judges of this sort can't ground their decisions on rules, their decisions instead come to rest primarily or even entirely on something else, their authority. Here, I think, is where Pound's judicial decisions, based on the concept of life that underwrites them, starts to become a decisionism. The essence of decisionism, as Carl Schmitt argued in 1934, is that we're obliged to do something not because it's good, true, or just, but simply because the sovereign commands it. Now, there's certainly a credible claim to be made that Pound is not a pure decisionist, for in his early writings, including Mechanical Jurisprudence, he implies that something he calls common sense should act as a constraining factor upon judges' ability to socially engineer the results they think are best. But in his 1908 essay, he also will refer to the need for, quote, our case law to rise to social and legal emergencies, and that is revealing. A theory of judicial decision constrained only by common sense becomes a pure decisionism. Once it becomes common sense, that in order to save lives, emergencies require the suspension of formal, abstract, and general rights. If that's what common sense dictates, then common sense is no longer a limiting factor on the decision. In this way, the decision on the concrete case, which so scrupulously refuses general, abstract, and formal concepts, throws itself into the arms of one of the most general and most abstract formal concepts in all of jurisprudence, in my view, and that is the idea of salus publica suprema lex esto, the idea that the safety or health of the law of the public is the highest law. This is the maxim of the jurisprudence of emergency. If, in other words, we accept Pound's premise that justice consists in a dual and reciprocal adjustment between law and life, then it's not clear why we would reject the conclusion that rule by decree is necessary in situations where an argument could be made that the public safety or health is threatened. This is, of course, exactly what President Hindenburg concluded on February 28, 1933, when he signed the emergency decree for the protection of the German people, which suspended many of the general, abstract, and formal protections stipulated in the Weimar Constitution. That Pound's thinking is susceptible to this conclusion is not, of course, mere conjecture. In the summer of 1934, Pound traveled to Germany to accept an honorary law degree from the University of Berlin. While there, he dined with the leaders of the Nazi-affiliated Academy for German Law, including Hans Frank, the notorious jurist and war criminal who was head of the general government in Nazi-occupied Poland. In August 1934, more than a year into Germany's state of emergency and just a month after the Night of the Long Knives, Pound gave an interview to an Austrian newspaper in which he said that he was, quote, everywhere impressed by the absence of tension and by the peaceful manner in which the people accepted Hitler as their leader, end quote. As Peter Rees of Boston College has shown, Pound attributed the rise of Hitler to Germans being tired of internal bickering and anxious to support someone who could bring them freedom from agitating movements. With regard to the long-term prospects for the National Socialist Party, Pound stated that he saw, quote, no reason why it should fail if it continues to attract the confidence of the people, end quote. This makes sense within the horizon of Pound's thought, for if justice consists in a mutual adjustment of law and life, and if, moreover, life is understood in Darwinian terms as the survival of the fittest, then it becomes difficult, I think, for Pound to say that Hitler's Germany is unjust. For Nazism, as Franz Neumann, Hannah Arendt, Roberto Esposito have said, it involved a significant integration of Darwinian thought into its law and politics. If Pound praised Nazism instead of objecting to it, perhaps then this is more than a merely personal failing. Perhaps it tells us something, in other words, about the conception of life that allowed him to critique mechanical jurisprudence. This brings me to my third and final thesis. It's also the most kind of tentative thesis. It's the following. The true antithesis of mechanical jurisprudence is not a new theory of the judicial decision, but a new theory of the judicial institution. In particular, I think Pound teaches us that we need a theory of the institution that allows us to understand the way in which institutions properly conceived provide the non-legal and non-scientific conditions for the integration of law and science. This thesis may come as a surprise, but it's suggested, I believe, by the teachings we've so far derived from Pound's text. According to Pound, remember, mechanical jurisprudence is bad both for law and for science. It not only derives from an unscientific concept of science and undoes the legitimacy of legal institutions, but in so doing, knocks the relation of law to life out of joint. Pound's solution to this problem, as we've seen, involved a new theory of judicial decision, which was grounded in the last instance in our Darwinian concept of life. But, in my view, that theoretical solution is itself its own problem, for it seems to lend itself to precisely the kind of decisionism that Pound himself, in the historical concrete, seemed to embrace in 1934. We are then led to wonder whether there is any other way besides decisionism to respond to the problem of mechanical jurisprudence. The institution helps us with that, but first, one more word on why I think this last thesis is important. I think it's suggested to us in particular by our own moment. Today we live, I think, at a moment when a new kind of machine is presenting us with the specter of new forms of mechanical jurisprudence. Today, I think, we find ourselves obliged to imagine new ways for jurisprudence to run automatically on its own, unthinkingly, repetitively, involuntarily churning out results that have nothing to do with the actual lives of the populations which it governs and which we must take on faith. I'm referring, of course, to the famous paradox of AI, according to which we do not understand its methods, but we understand its results, which, as AI engineers themselves say, is a specifically oracular conception of what it means to accept a conclusion. We therefore find ourselves, I think, in need of a response to a new kind of mechanical jurisprudence. Under these conditions, Pound's text, I think, is useful to reread and rethink, for it suggests that while the problems we face today are new, the form in which we encounter them is not new. And the oracular is just one among many examples. And yet, I think we can't deny that Pound's response to these problems is at best insufficient, and that part of that insufficiency involves the concept of life that's the premise for his critique of the lifelessness of mechanical jurisprudence. Although here, in conclusion, I can do no more than gesture at the beginnings of an argument, I think that the idea of the institution properly conceived can provide a non-Poundian response to the problem Pound identifies. The primary task of an institution, argues the Italian philosopher Roberto Esposito in a recent book, is to allow a social ensemble to live together in a given space while also and at the same time ensuring intergenerational continuity in the face of ongoing crisis. Institutions thus involve a very precise relationship to life, time, and thought. Because every institution, I think properly conceived, is in the concrete dedicated to a general purpose, such as justice in the case of the judiciary, truth in the case of the university, information in the case of journalism, God in the case of religion. Because there's a general purpose that regulates every institution, the institution in each case also allows for human beings to serve a telos that's in excess of their own immediate life. Whereas Pound's critique of mechanical jurisprudence depended upon the postulates of Darwinian evolution, institutions presuppose a conception of life that is guided by a purpose other than more life. In so doing, they not only provide an answer to the question of what is a meaningful human life, a question that is today renewed for us by virtue of AI, but institutions also provide a form of life that in principle sets a limit on the administration of life by powerful bureaucracies. Whereas Pound's critique of mechanical jurisprudence opposed the government of the living by the dead, the institution properly conceived entails relations of intergenerationality that allow for equilibria between the young, the old, the dead, and those not yet born. Therefore, a kind of imminent concept of secular time as the time of generations. Properly understood, an institution is not a noun, but a verb. Institution is the ongoing act by which I form my life in relation to a community that pre-exists me, such as a university, and also is here with me in the form of my colleagues, in the form of us, and in relation to which we all form our lives in connection and on the basis of some shared telos. So institutions have a horizontal dimension in that they integrate kind of diverse populations into each other, in relation to some shared concept, truth, justice, information, God, what have you. But they also have this vertical dimension that you see Pound is struggling with continually to kind of think about. The institution properly conceived doesn't then assume that intergenerational continuity is a natural and an inevitable fact of biological reproduction. Instead, it poses continuity as a problem for thought and as a question to be resolved by purposive rather than paternalistic administration. It therefore allows us to begin talking about the non-legal and non-scientific conditions under which law and science may be fruitfully integrated. For a long time, I think, at least since Pound, jurisprudence has left the question of the institution to sociology. Today, I think, for the sake of law and life alike, we have to ask ourselves how we might relearn to pose that question to ourselves and for ourselves. Thank you.
Yeah, thank you very much for this great thought-provoking presentation. We are now in the Q&A session. We're a group of international students. I'm sure there are questions or comments. Again, the event will be recorded and uploaded to YouTube, so you can either raise your hand or write down your questions in the chat box. If you do the latter, I will read them out for you. So actually, I think I will start off with a question, and my question relates to your first thesis. So it was very interesting for me to have this talk. 2 years ago, basically, we tried to write a mission statement for law science, and we thought, I don't know how many hours, Simon will be able probably to take a lot of hours, because we had very different approaches to what we think the relation to law, between law and science really is. And I think two aspects that you mentioned are very important in that context. So one is if there is something inherently unscientific in the concept of science itself. And kind of related, the second question is really, why do we want science and law, right? So what's the motivation? Because if there's something unscientific to the desire of having science, law and science, science and law, that brings us to the question of really the politics of the why, right? So the politics of why we want law and science. And as you have shown multiple times in your talk, there is a kind of a real life tension there, because on the one hand, we have sociological jurisprudence, which we commonly think of as a progressive thing, and an offspring of that is legal realism. And of course, one important offspring of legal realism is critical legal studies. On the other hand, you have shown that there's some real attraction to like common good constitutionalism and decisionism. Another offspring, by the way, is law and econ from legal realism. So there seems to be a real political tension between like who is attracted to that view. And then my question is, do you have a theory of, or what's your theory of why or how we end up with this opposition? Is it basically that the progressives have always misunderstood that this is really inherently a decisionist and conservative or reactionary even like concept? Or is there some openness to it that just makes it available for different politics?
Sure. So there's a lot there. Let me first say the following. I proposed that first thesis with AI in mind, because the proposition of AI is that it can understand our desires before we can understand our desires. I take a lot of AI to be saying this. A lot of algorithms can kind of say, you didn't know you want this, you wanted this, but in fact, you wanted it. And when I'm shopping on Amazon and it's proposing a product, that would be an example, and so forth. So we're at this moment when a certain science, computer science, is kind of proposing to integrate desire into itself and be more than Freud and differently than Freud. And so that's my understanding of AI, and I'm sure that there are people with a better understanding of it. If I'm incorrect, please say so. But I wanted to kind of put that on the table because I think it's something we need to think about today. So that's A. B, I do think that huge swaths of critical legal studies kind of depart from this premise, the idea that there's a non-scientific kernel to science. And my critique of that tradition is that I don't think it's fully understood that the question of desire is also the question of moral philosophy, of why do we want what we want, and whether what we want is really good. And so it's perfectly possible to kind of say, well, there's a kind of implicit kind of normative bias in the way that certain judges make certain decisions. And I am persuaded by those studies generally. I find those kind of clarifying. But I think in many cases, those kinds of studies leave in silence the moral philosophical question, which is to say, well, what is the good and why should I want the good? And how do I persuade you that the good is the good? On what basis? What forms of argumentation are adequate or appropriate to this question? So that, first, I want to tie that to AI. I think, as some computer scientists say, moral philosophy in the age of AI is a growth industry, because moral philosophy is the question of what kind of the way that we frame algorithms, and the way, there are moral decisions involved in the way that we put together kind of algorithmic or large language models, any of these things. So I think that moral philosophy is important, not only for reading Pound, but also important for our moment. And I do think that this kind of like silence around moral philosophy within progressive thought in particular is what accounts, Daniel, for the splits that I think you're pointing out. I think that evolution has kind of done a lot of work for legal realism, the idea that we're adapting law to the kind of evolving needs. That's literally the phrase that comes up over and over and over again. and we use it unthinkingly. But if we really had to think about what conception of life it is that we're trying to adjust law to, and why that life is a good form of life, I think we would be engaged in a moral philosophical debate. So I don't know how useful that is, except to say that I think that that's what Vermeule is doing. He's saying, let's robustly kind of make the administrative state serve as a means to the end of outright moral goods. Let's not accept this kind of like early modern liberal pact, which separated out mere life from the good life. And I'm thinking of Hobbes in particular, the preservation of life independently of moral questions. I take Vermeule to be wittingly or unwittingly reopening that kind of founding question of modern secular law and saying, okay, let's have that moral philosophical debate. So for a variety of reasons, I think we're at this kind of moment when we have to kind of revisit these classic questions and kind of renew our appreciation of the rhetoric of moral philosophy, if we don't want like a kind of new theological civil war. So Daniel, I don't know if we're talking to each other, but that would be my response about desire.
No, yeah, I love that answer. Thank you. Simon?
Yes, thank you, Daniel, and thank you, Adam, for this amazing presentation. I think this reflected a lot about what the Law of Science project is really about. What is our focus? And one thing that actually caught my attention, I was thinking about, you know, your whole presentation, about one thing about law that is very unique, different from a scientific discipline, is that there are different actors here. There are lawyers, there are judges, and there are academics. So the highest form of achievement, let's say, in the legal academy is to work in the Supreme Court or like the honorary court, however, you know, the system is. And then that court itself, the highest honor there, at least in the United States, is how you can implement your philosophy, you know, your normative value judgment, right? Which is very different from, you know, in scientific kind of discipline, where the highest form has to do a lot with, you know, the search of objective truth, right? So then the first question there is, do you see a significant difference, or maybe development even, on the role of a legal academic, right? It's a lawyer who actually does a PhD and writes something, or just like in terms of the pursuit itself, that is distinctly different from what a judge or what a lawyer does in the pursuit of, you know, treating law as science. So that's the first question there. The second here is I wanted to ask further about your thoughts about artificial intelligence and its relationship towards kind of law as science. So my question here is, are you talking about like code is law, that kind of like Lawrence Lessig, who talks about whatever governs our behavior right now has to do with algorithms, or is it something, or is it different from that? And there's also, you know, there's also another kind of representation about artificial intelligence, right? So there's large language models, which you have to feed data, and then you have a model, and then either if it's open source, then you can just directly employ that. But it really depends. If it's proprietary, then there's also financial kind of means of attracting people's attention to use more of your product. But there's also the decentralized autonomous organization, where you have AI there to help encode transactions through smart contract. And that is like an automatic kind of decision making there. So I was wondering kind of maybe what we can learn here through AI in terms of either they need to gather data, the type of AI itself, the employment of AI. Yeah, would love to hear this part of your thoughts. Thank you.
Sure. I mean, let's take the first question. And so I do think that truth and justice are intertwined, kind of teloi, or telos in the plural, and they kind of circulate, and they share a language. I think the best text on this is actually by a French philosopher named Michel Serres, called The Natural Contract. And he has a whole chapter called Science, Law, where he goes through and kind of documents the differing modes of relations between science and law for millennia. But in terms of in the concrete and in terms of your question, I would say two things. Like I'm with Weber when Weber basically says, look, to some extent, kind of like scientific inquiry is not necessarily normative inquiry. Those are distinct. And I take Weber to be saying in 1917, like it's really the kind of scientific endeavor is to kind of follow the argument where it may lead, and without necessarily kind of always predetermining that on the basis of normative values. And so what I conclude from that is that there's this kind of scientific attitude that requires me to kind of hold my normative commitments at a distance and have kind of intellectual restraint with respect to them. And it might be futile, it might be tragic. And Daniel, this is another way of answering your question, you know, the kind of value-free or value-full kind of judgments kind of stands in the same relationship to kind of like, it stands in a kind of homologous relationship to desire and for the desire for science and science. But I think like if there is science, and I think there is, then it would mean that I have to kind of say, I have to depersonalize those value-free judgments, or those value judgments, and I have to be intellectually humble about the fact that my value judgments might come into conflict with others. I accept your portrait of the Supreme Court, and I think that nothing even remotely resembling that is happening, that exactly as you're saying, I get appointed, and then like tenure allows me basically just to kind of like impose my normative judgment, you know, damn the torpedoes and so forth. But that's why I think Pound is so interesting, because as Roberts, I think, clearly sees, that is undermining the institution of the Supreme Court itself. And it can't happen for much longer with impunity. So the instances, so I think what's kind of like misunderstood in the kind of philosophy of the abuse of judicial tenure is the idea that legal institutions rest on non-legal kind of forms of reverence, and we don't really, I think, want to experiment with what that lack of reverence looks like. So I hope we're talking to each other, but I think that I think Weber is very useful on the idea of the differing forms of judgment and the forms of intellectual humility and restraint that are involved with respect to normative commitments when I'm an academic, as distinct from maybe when I'm a judge. There's a lot more there, but let me talk about AI. I mean, most directly for those of us gathered here today, I think, and prosaically, AI is going to automate a lot of kind of lawyerly tasks. A lot of it's mechanical to begin with, and already has for many, many years. And so we can talk about LLMs, but at a more kind of basic level, LegalZoom is kind of doing the work that a lot of lawyers would have done in the past. But I think that kind of raises a couple of questions. One, it's like, I think it really asks us to think like, you know, well, what is our problem with AI? You know, like on what basis are we critiquing it? Like, you know, what is thinking such that we're kind of like calling it thinking? And if it can do the thinking that we are doing unconsciously, then what does that say about our own thinking? So I think there too, like, in addition to there being like a straightforward kind of like economic argument about the displacement of like lawyerly labor with AIs, I also think that there's a kind of deeper question that AI poses to us and makes this moment fascinating for because of the first order questions that it's posing. And AI can pass a lot of you know, bar exams. It can pass, you know, as you've all seen those you've all seen those kind of news stories about how it's passing kind of tests at various law schools. So I think that shows that a lot of the jurisprudence that we've been engaged in has already been mechanical for a long, long time. And it requires us to visit what Daniel said before the session started, visit this really interesting snapshot in time in the 1930s, when not only Pound, but also kind of Schmidt in really, really objectionable ways are asking about concrete order thinking, about institutional the institutional substrate of law. And the kind of cognitive or merely epistemic elements of law might be subsumable under AI or might be performed by AI. But then we really need to ask ourselves about how that's going to play with respect to concrete populations. One more point, I'm talking more than I wanted to, but it's commonly said, and this is a reason why I turned to Pound as well, that AI poses a question about the limits of faith and reason and their relationship to each other. The so-called black box problem is the so-called oracle problem, and provides for us a kind of moment when the apex of a certain kind of computer science, like real brilliant reason, is producing a situation where we have to think about questions of faith once again. And in particular, this is an actor, Simon, that figures prominently in Pound, but in particular, my reverence or faith as a kind of just common person, that what the Supreme Court is saying is actually law and not politics. And that faith is being shaken. So that's what I think the kind of takeaway from Pound is that we really need to think about the kind of non-epistemic, kind of deontological, the deontological questions that allow legal institutions to kind of nest these epistemic questions, if that registers. So I don't know if we're talking to each other, but that would be my go at that question.
So unfortunately, we're out of time. But so the first thing I want to do is just, if you can, please switch on your cameras for a second so we can take a snapshot photo. And then the second thing I want to do is really thank you so much for the presentation today. I think the discussion and the presentation was great. At least like I learned a lot. So thank you so much, Professor Adam Sitze, for joining us today. Thank you everyone for attending. Our next session will be in 3 weeks, very different but equally fascinating topic, October 3rd. Martin Fruguli will speak about cognitive biases, particularly on platform e-commerce. I hope to see you there again. Thanks, Professor. Thanks everyone for joining us. And
all right, thank you for coming. All right, nice meeting you.
Thanks.